Just because the police make these certain findings against you when they bring a charge of DWI, that is not the end-all and the be-all. These findings can be challenged, and that is why you need a effective attorney who can know where to question and challenge those findings. For example, with the observations by a police officer that he believes you to be intoxicated. Again, if they do not perform these tests on you, these field sobriety tests, in an appropriate manner and legal manner, those tests can be thrown out and disregarded by the judge. And also, if there was a subsequent blood alcohol reading that finds you above the legal limit of 0.08, that can also be thrown out, even though that was perfectly fine. The reason for that is because if the initial field sobriety tests were conducted inappropriately and improperly, everything that followed from that, your arrest and subsequent alco test results, can all get tossed. And in that manner, an effective attorney who is sophisticated and knows about the different issues that can be raised can get a drunk driving charge dismissed. In addition to challenging the observations of the police officer, there may be other witnesses. You perhaps had friends who observed things. They could come in to testify on your behalf. We also, as part of our discovery request, you're entitled to full and complete discovery of all evidence against you. We make sure that we have all of that discovery. We ask for any type of video or surveillance that the police may have conducted on you, such as a dash camera. If that was on and running while they stopped you and performed these field sobriety tests, and it appears from our looking at those videos that you do not act impaired, that could be very significant evidence to show before the court. And the judge might decide, well, after he looked at that evidence, it did not appear to him that you were as drunk as the police report said you were. So that's another way that we could attack and challenge those police determinations. There are numerous ways to try to challenge the validity of the breathalyzer machine. We would retain an expert witness. We work very closely with an expert who was a former New Jersey State police officer who was a pioneer in the breathalyzer machine. He is now retired, and we retain him for virtually every alco test reading case that we have, and it's his job to review every shred of evidence that we get in this case to determine whether every single step and every procedure was employed properly by the police department. The police are also obligated to perform routine maintenance checks on those alco test machines. We get the results of those maintenance tests. If there's any indication that there was some type of flaw in the machine, we bring that to the attention of the court or the prosecutor in the hopes that we might be able to dismiss the reading. So we would possibly be able to get the case, if not completely dismissed, get the charges lowered enough so that you would only be facing a 3-month loss of license instead of a 7-month or 12-month loss of license. Also, if there are blood findings, there are very strict requirements in New Jersey for obtaining a blood sample from you. If you're taken to the hospital, most of the time now, under the case law, it's required that the police obtain a search warrant to have your blood extracted. It must be extracted in a medically professional, safe environment, number one. And number two, you have the right to object to its taking. However, if they do obtain a search warrant, they could extract your blood sample against your will. But we also have an expert who is very familiar with the procedures for extracting blood and how to read blood test results. So we employ at every step of this process anybody who we think might assist us in giving you the best, most aggressive defense that we could possibly provide you. So those are some of the ways that we could attack the police report and the police determination that you were in fact driving under the influence.